Right.
Hi.
So they're still not here yet. Hey, quick question.
Yes.
I went into the other room and I checked with the other screen. Am I live? Oh.
Yeah, we're live. Yes.
Oh. Okay, I checked with the other screen and I was looking at the closed caption that we discussed earlier. But when I checked on the other screen, it wasn't giving me that option to do closed caption.
Does it work on this screen?
I could try on this screen to see. Okay, it does work on this live screen. Okay. Okay, thank you.
Thank you.
All right. So let's see.
Good morning.
Morning,
And what is your name?
Scott Dennis, 368-935.
Well, good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Scott Dennis, 368-935. Today is Tuesday, November 5th, 2024. This hearing is being conducted via video of the Board of Pardons and Parole Central Office and Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Scott Dennis, 368-935.
This is a public hearing. Public access to this hearing is available via video live stream. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Dennis, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. First, I will read your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to present all relevant testimony. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney at this hearing. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or do you want to proceed without?
Proceed without.
You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, I do.
We now will review the charges that the state your officer is bringing against you and the information underlying each charge. Charge 1, residence. On September 4th, 2024, around 9:16 p.m., residential supervisor McFadden witnessed you walk out of the front door of your only parole-approved residence at Chase Center Halfway House in Waterbury, Connecticut. She followed you and asked if you were leaving. You stated yes and told her thank you. R.S. McFadden reported that you were upset around 7:15 p.m. to 7:45 p.m. You disclosed that you called your pregnant girlfriend and saw that she was high. This PO attempted to locate you by calling your cell phone and your mother's cell phone, but was unsuccessful. Neither you or your mom returned this PO's call. Your whereabouts in the community were unknown until Wilton PD located you on September 6, 2024, after receiving a call from your girlfriend, suspecting you have overdosed. You were unaccountable in the community for approximately 48 hours. Your actions violated your parole conditions, specifically release directions. I will live in a residence approved by my parole officer. The state's exhibits were marked and identified on the record at the preliminary hearing on September 23rd, 2024. Did you receive the notice of parole violation report, and the other documents that were marked for identification purposes? The evidence packet you should have received upon your incarceration.
Yeah, I got it a couple weeks ago.
Okay. Today we have no witnesses. And it is now your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. Do you wish to testify in regards to the allegations?
I didn't know I was having a hearing today, so I'm not really prepared. Like I said in the preliminary hearing, I left the halfway house. I shouldn't have did it, you know. It was a bad environment for me, but at the end of the day, I made my choice. I take full responsibility for my actions. I need help, you know. I'm asking the Board of Parole to help me with a rehab bed, something with that nature. I do have 2 babies coming up in a couple months. They're my first. And I wasn't on my medication for my mental health, and DOC has helped me get back on my meds. So now I'm more stable, you know. I was going off emotions, and, you know, that's all I got to say.
Okay, thank you. I'm going to take a moment before I announce my findings. On charge 1, residence, I make a finding based on state's exhibits B, C, and E. That concludes the fact-finding portion of this hearing. Before I make my recommendation, you have an opportunity to speak to your background and history. So what is your release plan?
If I were to be released?
Yeah, what would be, like, would you want, you said a rehab bed, or do you want a halfway house?
I would like to get back in, I'd probably go to a different halfway house if that's available in a different town. Waterbury is, you know, where I used to run around in. Or I could go back to mom's. That's something I have to talk to her about. But I would like to go into like the App Foundation, some kind of like residential treatment program. Because I want to be there for my kids, you know? What
town would you like to be placed in?
For a halfway?
I know you said not Waterbury, for a halfway, yeah. And then your parole officer would be able to.
I'd like Bridgeport.
And what is your relapse prevention plan?
I got to get back into CCAR. I was working with a recovery coach. You know, I started slacking in that area. I was due to work. I do construction, you know. I didn't put my recovery first. And if I don't do that, everything else is just going to crumble. And that's what happened. Go to NA meetings, find a sponsor, continue with IOP. Just be very active in the sober community. You know, I got to put my recovery first, like I said. Everything else comes second.
Okay. So you would like to be placed in a halfway house in Bridgeport, and at that point, you could work with your parole officer to discuss, like, you know, the App Foundation or further treatment. And you plan on working with CCAR because you have to at least put your recovery first. So that's your plan. Putting your recovery first and being placed in the Bridgeport area. Okay. In terms of employment, you want to first work on your recovery, or do you have an employment?
I have employment opportunities, but like I said, I made a mistake where when I came out the first time, I went right to work overtime, and it was just too much to balance after I did 3 years, and I wasn't ready. You know, I was running too fast, and I got to do baby steps. But I do have some employment lined up with my old jobs, you know.
Okay. And what would be your first choice for work?
For my job, construction.
For job, because you have a few. So
I'm a plumber. I have my plumber. I'm doing my apprenticeship through a program through the job I was working for.
And where is that?
DSO mechanical plumbing.
DSO?
SO, yeah, mechanical plumbing.
Okay.
And I also have a job opportunity with another job, On Point Layouts. It's also a plumbing surveying company.
Okay. Anything further you plan on doing upon your release back into the community?
Being there for my kids. I got 2 newborns, 2 twins coming up in January 25th. They're my first, and I got to support them and my family, you know, so, okay. You know, recovery and the babies come, you know.
Okay. I'm going to take a moment before I announce my recommendation. Okay, since this is your second opportunity in the community, since being on special parole, since being on parole, and you left the halfway house only after being in the community for 10 days, I recommend revoke and reparole on March 6, 2025, which is an approximate 6-month sanction with the following conditions: no consumption of alcohol, halfway house placement, no contact with co-defendants Miranda Augusto and Sean Perry, and mental health evaluation. My findings and recommendation will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on November 14th, 2024. So on November 14th, the board is going to look at your case. They can either lessen my recommended sanction, let my recommendation stand, or impose a sanction longer than what I have recommended. You will know the board's decision on or about 11/14/24 because you're going to get it sent to you to the facility. Okay. And if they will
say it again?
The March 6th, 2025. Yeah, so
Okay.
it's a 6-month sanction. But again, the board can lower that recommendation, keep that recommendation, or exceed that recommendation. If they choose to exceed that recommendation, then another hearing, which is called a supplemental hearing, would take place. And at that time, you will be provided with a written notice documenting the specific reasons why they might want to exceed my recommendation. Okay, but again, November 14th, on or after that date, you'll know the board's final decision.
So I'll get something in the mail?
Yes, yep.
Okay.
All right, thank you so much.
All right,
You're
thank
all
you.
set.
Have a good day.
You as well. Mr. Kawiecki, being that you said you're hard of hearing, we're going to put some closed captions on for you, so you'll be able to read what I'm saying across the screen.
Yeah, he said he's gonna put a closed caption.
Yep.
Yeah. All right. How you been? Okay?
Good. Thank you for asking. How are you?
Oh, good. No complaints. The weather is beautiful. Yeah.
That it
I
is.
have a good feeling there'll be a good outcome today. The warden came to the dorm and everything. Good morning.
So if you press the 3 dots, it should show live captions at the top of the list.
Right up there. So it should be on now.
Yeah.
All right.
So usually
do you
there's a
see
black bar on the screen, and then I'll talk for a moment just to see if the words do appear for you.
Okay.
Is anything showing up on screen?
No, nothing is showing as yet.
Do you see the black bar?
Yes, I see a bar there. Okay, hold on.
What they have for technology today is unbelievable.
Did you try speaking again?
do you see anything at this point?
Caption.
Yeah, it's turned on, so.
Yeah.
Okay.
Yes,
Okay.
Let's see how it goes. Yeah.
okay.
I could hear it pretty good.
You can hear it pretty good.
Yeah.
Okay, he says he can hear you pretty well also.
Yeah.
Okay. So good morning. My name is Parole Officer Saunders. I am a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Andrew Kawiecki, 141235. Today is Tuesday, November 5th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
I heard that. Andrew Kawiecki.
And your inmate number? Your
Say
inmate
again?
number? Your inmate number.
141-235.
This is
I'm
a
yelling,
public
ain't I?
hearing.
Yeah.
Can you
Am I
hear me?
shouting?
No, you're
I-
fine.
Yeah.
Okay, but you can hear me.
I could hear you, yeah.
Okay, and is the closed captions on the screen?
Nothing.
No? Okay.
Nothing. No.
So if you can't hear something I'm saying, just stop me and let me know.
I will.
Okay.
Pretty good so
This is-
far.
This is a
Pretty good
public
so-
hearing.
Yeah.
Public access to this hearing is available via video live stream. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. Wait, I'm just reading the procedure. Okay.
All right.
If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Kawiecki, please raise your right hand. Please raise your right hand. Please raise your right hand. I'm placing you under oath for your testimony.
Yep.
Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
So help me God.
Okay, thank you.
Yeah.
First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to present all relevant testimony. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin? Do you have any questions so far?
Questions?
So I just read you the procedure. So what I'm about to do now, I'm going to read you the charges against you that your parole officer has brought against you. I'm about to read those charges.
Okay.
Then after that, I am going to announce my findings. Okay. And then
Okay.
after that, I'm going to give you my recommended sanction if I go that route. I just went over that. I just read all of that's the procedure that we're about to go through.
Yeah, all those were like misconduct, misunderstanding.
Okay. Wait, so I have to read you your rights first.
Yeah.
I have to read you your rights. You have the right to be represented by an attorney at this hearing. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or would you like to proceed without counsel?
Yeah.
Do you want an attorney for today?
Yeah, I don't want no attorney. Yeah, nothing like that. No.
Okay. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. And at this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand your rights? These rights I just read to you, do you understand them? Okay.
Yep.
We now will review the charges that the state your parole officer is bringing against you. So now I'm about to read all of the charges against you, okay?
Yeah, because, yeah, yeah,
So I'm going to read them to you first, and then you'll have an opportunity to speak regarding the charges.
I don't mind. No.
So for charge 1, program participation, on November 29th, 2023, you were instructed by your parole officer to participate in a mental health evaluation and comply with any treatment recommendations. You completed your evaluation at CRT in Hartford, and you were recommended to participate in DBT and CBT groups. You failed to attend mandatory CBT groups on March 21st, 2024, March 28th, and April 4th, 2024, as instructed by your parole officer. Additionally, you failed to attend your appointment at CRT for a co-occurring evaluation on April 4th, 2024. Your actions are in violation of your special parole condition, which states I will be assigned to one or more several levels of a community supervision and agree to participate in programs as determined by my parole officer. Charge 2, employment. Oh, one sec. I'm just reading the charges.
Okay.
I'm reading it.
I'm just gonna say, like, I participated with everything. Everything was like misunderstood. Yeah.
I'm gonna read all, these are just the charges. I'm gonna read them.
Yep.
So on charge 2, employment and community service, I already made a no finding at your preliminary hearing for that. So I'm not even going to read that charge because I already made a no finding and the state didn't provide any new information.
Yeah.
Charge 3, halfway house placement. On July 22nd, 2024, you signed out of Eddy Center Halfway House on an approved community pass to attend a job interview at Martin's Rosos Inc., located in New Breton. Your pass was issued with a scheduled return time of 12 p.m. and you only had permission to attend the location of the interview. You failed to return at your scheduled return time and you did not contact the halfway house to report that you would be late. Attempts to locate you were unsuccessful. You subsequently returned to the halfway house at approximately 4:15 p.m., making you unaccountable in the community for 4 hours. Additionally, you returned to the halfway house with bags of items you allegedly purchased at the store, indicating that you deviated from your community pass. Your actions are in violation of your halfway house agreement, which states, I will return to the halfway house from community pass at my scheduled return time. And if I am unable to do so, I will call program staff to explain why I'm expected to be late and return with a new return time. And also, I will only go to the locations indicated on an approved community pass unless changes have been made and authorized by staff. On July 23rd, 2024, you refused staff's instruction to leave the halfway house staff office and called the staff assholes. Your actions are in violation of your halfway house agreement, which states I will treat others with respect and not engage in verbal or physical altercations with offenders, staff, or third parties. On August 23rd, 2024, you signed out of the Eddy Center Halfway House on an approved community pass to attend your mandatory groups at Willard Clinic, AIC, in Middletown. Your pass was issued with a scheduled return time of 4 p.m. You failed to return at your scheduled return time, and you did not contact the halfway house to report you would be late. Attempts to locate you were unsuccessful until you returned to the halfway house on August 29th, 2024, making you unaccountable in the community for approximately 6 days. Your actions are in violation of the halfway house agreement, which states I will return to the halfway house from my community pass at my scheduled return time. If I am unable to do so, I will call program staff to explain why I'm expected to be late and to receive a new return time. And also, I will only go to the locations indicated on an approved community pass unless changes have been authorized by staff. So the state's exhibits were already marked and identified on the record at your preliminary hearing held on September 23rd, 2024. So I'm not going to rename them because we have no new exhibits that were filed. So today, Mr. Kawiecki, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes? That parole package, your parole evidence package, did you receive it?
Say that one more time.
The parole package that had all the evidence in it, did you receive that packet?
Oh, yeah.
Okay.
The paperwork? Yes,
Yep.
it did. Yes, it did.
Okay.
Yep.
So
Correct.
now it is your opportunity to respond to the parole charges against you.
Yeah.
Remember that you may remain silent if you choose to do so. Do you want to testify in regards to those charges?
I don't know why they charged me with all those. I already, got, every time they wrote me up for whatever, I did what they told me to, like, don't do community service and, they took my, ordering food out, I lost money and I complied with, I don't know why they put all that together. The only reason is that I left the halfway house for that 6 days is to get their attention because I went to the director and she told me to go F myself. I said, I went to every source and I said, you know what, I'm gonna take 6 days and come back and take it easy. Like, cool down, because I wasn't getting nowhere when I went to the right person and they're telling me they're in charge and the smoking on state property. I just had enough. I had enough, I didn't commit no new crimes, nothing like that,
Okay, anything further?
I'm sorry?
Anything else you would like to testify to regarding your charges? Anything else?
The only thing is I wish they would be more educated on people with loss of hearing and, it just, I don't know. This time when I get back to a halfway house, I'm gonna just make sure I have, like, stay, like I went to community service, I'm gonna take a picture, if there's a sign, temporarily closed, I'm gonna bring it back and have them copied. That was my fault. Yeah, I did everything they wanted. I got jobs and that, and I can't believe that they wouldn't listen to me for 5 minutes. So now I got their attention.
Okay.
That's all, yeah, that's all we got to say. Yeah.
All right. Thank you.
Yeah.
I'm going to take one moment before I announce my findings. Okay. I'm going to take a moment.
Okay.
On charge 1, program participation, I make a finding based on states exhibits B, D, and EE. On charge 2, employment and community service, a no finding was already made at your preliminary hearing and is not being considered at today's hearing. On charge 3, halfway house placement, I make a finding based on states exhibits B, D, E, W through Z, AA, and CC. That concludes the fact-finding portion of this hearing. Before I make my recommendation, I'm going to, this will be your opportunity to speak to your background and history. So what is your release plan? Upon parole reinstatement, where do you plan on residing? Employment opportunities, what is your plan?
Say that one more time.
Your plan upon parole reinstatement. What do you plan on doing upon your release?
When my goal this time?
Yeah, your plan on where do you plan to live? Where do you plan on working?
That's my goal, and my goal is to take care of my brothers and help them out. One's in a boarding house, another one's in a group home, and another one's across the street in prison. If that's not a curse, I don't know. I have to help them out. So job and my family come second.
And where do you plan on living?
Living where I was born and raised, New Britain.
Okay, so a halfway house in New Britain?
Halfway house, I don't think they have halfway houses in New Britain.
It would be the area, so you would, or reach bed.
Yeah, okay. Reach bed in New Britain, yeah. The last job I had a 7-minute walk to work.
Now, if you can't obtain a reach bed in New Britain, what halfway house option would you like?
Halfway house, I would love to go back to Middletown, the connection house.
Okay. And do you have an employment opportunity? Do you have a job offer?
I have a 99% chance of going back to Carvel in New Britain. They expanded, 200 people are needed.
Okay, so working and taking care of your brothers. Anything else?
Yep. I'm sorry?
Anything else you plan on doing in the community? Is there anything else you plan on doing in the community? Aside from working and taking care of your brothers?
Anything else you said?
Mhm.
No more issues with halfway houses. Yeah, no more.
Okay.
Yeah, I'm done. Then that's a,
Okay. So, Mr. Kawiecki, so based on this being your second violation, this is your second violation of parole, I recommend revoke and re-parole on January 29th, 2025, which is an approximate 5-month sanction. So January 29th, 2025 is my recommendation. Okay? With the following conditions: no consumption of alcohol, no contact with victims CN and New England shop, and halfway house placement.
okay.
My findings and recommendations will be given to the board. They're going to look at your case on November 14th, 2024. So on that day, November 14th, the board is either going to agree with my sanction, which is January 29th, 2025, or they can lessen my recommended sanction, or they can go longer than what I recommended.
Okay, are you recommending me to what day of release you said?
January 29th, 2025, January 29th.
Jan 25, so.
No,
oh,
29th.
So, yeah, 25 is around the, in 24, so 25 is gonna be what, 2 more months?
Correct, yes.
So you're recommending 2 more months?
Yes, but the board has the final decision.
Let's pray together.
So they're going to, on November 14th, they're going to make the final decision on November 14th.
Yeah, that's what I thought. You guys were gonna call me November 14th, and they called me to the bubble and they said to come see you.
Yeah,
I knew it was gonna be a good day. I knew it was gonna be a good day.
So this concludes your hearing, Mr. Kawiecki. You're all set.
Oh,
You're done.
thank
You're
you
all
again.
set. Okay, thank you.
God bless. God is good.
Hi, Attorney Jones. Attorney Jones? I'm trying to reach Attorney Jones, but since she's not answering, we can go with Mr. McCarthy.
You want Mr. McCarthy now?
Yeah.
Okay.
Officer Saunders, Attorney Sirica is in the other hearing.
Okay, let me email Attorney Jones. Oh,
No,
there you
I'm
go.
here. I'm sorry. I
Oh,
apologize.
okay. Officer.
McCarthy.
Oh. I'm sorry. Mr. McCarthy's attorney is actually in another hearing. Is there any way I can get back Mr. Mathis? I'm sorry.
Okay. Okay. Sorry, guys. I gotta see. Mathis, you coming now?
Attorney Jones, I'm going to just put it on record, and then I'll allow you the opportunity.
Okay, thank you.
No problem. Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Brian Mathis, 372-016. Today is Tuesday, November 5th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Robinson Correctional Institution. Please state your full name and DOC MA number for the record.
Brian Mathis, MA number 372-016.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also Attorney Jones, who would like to have a moment with you.
Thank you. Mr. Mathis, my name is Sonia Jones. I'm a public defender of the Public Defender Parole Revocation Unit, okay? It's my understanding that you wanted representation for your hearing. However, we have a legal call scheduled to speak with you on November 7th at 10:30. For today's purposes, we would not be prepared to represent you today. So if you wanted a continuance, we could ask for a continuance, have that legal call with you, take your public defender application, determine your eligibility, and assist you with your hearing, or you could have the option to go forward on your own. So what would you like to do today?
Yes, we could, I'll take the legal call.
Okay.
I'll trust you guys.
Okay, thank you. Hearing Examiner Saunders, it would be our request then to have a continuance so that we can take his application, determine his eligibility, and likely assist him with his hearing if he's eligible.
Okay, continuance is granted. And Mr. Mathis, then my next available hearing date is November 19th. So that should give you plenty of time to speak with your counsel.
All right, thank you.
All right,
Okay,
thank you. So
that call is scheduled for the 7th, okay, at 10:30?
Yes, ma'am.
Okay, so expect that. Okay, thank you.
All right, thank you so much.
Yep, you're welcome.
So, I said that you said my next hearing is on the 19th?
Yes.
yes, that's my next available hearing date. So after you speak to your attorney, that will be the next hearing.
Okay, thank you so much.
All right, thank you.
Thank you. I'm going to go over to the other hearing room to address two other individuals who wanted representation, and then I'll be back for Mr. Marino and to address Mr. Griffin at 10:45.
Sounds good. Thank you.
Thank you.
Just stand by.
You can bring in Mr. McCarthy, but we won't get started probably for another few more moments.
Okay, that's fine. Just have a seat.
Mr. McCarthy, your attorney is in another hearing, so we'll get started as soon as he's done.
Thank you.
Mr. McCarthy, as you we're still waiting. There should be a few more moments.
How you doing, Trevor?
I'm good. How you doing?
Good.
Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. 1 second. This is a revocation hearing concerning Trevor McCarthy, 409-123. Today is Tuesday, November 5th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Robinson Correctional Institution. Please state your full name and DOC MA number for the record.
Trevor McCarthy, 409-123.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Sure. Attorney Alfonzo, Sirica, Public Defender with the Parole Revocation Unit on behalf of Mr. McCarthy this morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. McCarthy, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your officer, is bringing against you. Then I will review and identify exhibits filed for the records. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights in this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state, your officer, is bringing against you and the information underlying each charge. On charge 1, obedience to the law. On July 11th, 2024, you missed your scheduled intake appointment with the AIC for Employment Services. On July 16th and July 18th, 2024, you failed to attend your substance abuse groups at Willard Clinic. On August 14th, 2024, you were served a warrant by probation charging you with violation of probation. Subsequently, you are in violation of your special parole conditions, OBL laws. The state's exhibits were marked and identified on the record at your preliminary hearing held on August 30th, 2024. The state filed an addendum to Exhibit D, which states on September 19th, 2024, Mr. McCarthy appeared in GA Waterbury under docket ending in 290 for the charge of violation of probation. Mr. McCarthy received probation continued. Counsel, did you receive the notice of parole violation report, and other documents that were marked for identification purposes?
I did.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence to speak to any of the evidence submitted.
Yes, if I may, I know my client is charged with obedience to the law, but the obedience to the law is it's not a new arrest. It's a violation of probation from an underlying charge, and the basis of the charge obedience to the law is these missed appointments. I just want to make sure, I know you know, I just want to make sure the record is clear after speaking to Mr. McCarthy. My client did not go out and commit a new crime. Is he charged with obedience to the law? Yes, but the violation of probation is not a new crime that my client committed. He was also, and you're probably aware of this, he was under parole supervision. He was under IPS supervision. I brought this up at the preliminary hearing also, and he was being supervised by parole. So I just want to make sure, yes, it's the correct charge under obedience to the law, but I just want to make sure that the record is abundantly clear. My client did not go out and commit a new crime. His violation of probation was violated, and the allegation is not because, probation can be violated. Obviously, if you pick up a new arrest, there's also some requirements, and the allegations here is that my client missed some appointments here. He did go to court. I'm not sure if you put that down. I was looking at my notes.
September 19th.
Correct. They did do a probation was continued. Obviously, it was continued because, like I said, these are quote unquote technical violations of parole, of probation, and we use the same term here. But once again, my client did not commit a new crime. We did put on the record, I believe in its preliminary hearing, my client had indicated on July 16th, I understand he did miss his appointment. He did start a new job on July 16th. And Mr. McCarthy, you're under oath regarding the July 18th of 2024 regarding the substance abuse group at Wheeler Clinic. And I know you went through the evidence. Do you have any, unless sometimes things get up, do you have any evidence that the state presented regarding anything from Wheeler Clinic about my client not going that day?
On July 18th?
Yes, besides what's in the
PBR
violation report. And Mr. McCarthy, in your own words, could you please let the hearing examiner know, did you actually go on July 18th, and what occurred if you did?
Yeah, I went on July 18th. I had scheduled work for the 16th and the 18th, but I canceled the 18th and went to the program. But there was only me and somebody else in the program. They can't start a program unless there's 3 people involved in the program. There's only 2 people, it was just me and somebody else.
And that's for July 18th, correct?
Yes.
Okay, your testimony under oath today is you went to the program on July 18th, correct?
Yeah.
There's only 2 people there.
Mm-hmm.
And the program, there was no class that day. That's your testimony.
No.
Okay. I just wanted
And
to.
I was on GPS, so.
Correct. They knew where you were. Correct. And that's what IPS, intensive pretrial supervision, includes that. And I'm sure that. So I just, like I said, I want to just put on a record at the time of the remand where my client was charged with obedience to the law. He was reporting to a parole officer, and there's obviously no allegation that he did not report to his parole officer. The basis of the violation of probation is some disappointments at an AIC at Wheeler Clinic, where then he was served with the violation of probation. He did go to court, and they did continue his probation.
Anything further?
Not for the first part of the hearing, no.
I'm going to take a moment before I announce my findings. On charge 1, obedience to the law, I make a finding based on State's Exhibits B, D, and E, as well as the court's disposition of probation continued. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. If you wave your hands, the light will come back on.
There you go. We can see it. Yes. On behalf of Mr. McCarthy, my client is 31 years old. They indicate he's been remanded since August 14th of 2024. And once again, I understand he's charged with obedience to the law. The basis with the violation of probation, he's resolved that matter. They continued probation. So hopefully upon his reinstatement, which is going to be hopefully sooner than later, he's got parole supervision. He's got probation supervision. As he indicated, he was an IPS that had a GPS on him. He's not charged with any of those violations, obviously. So he is being monitored closely by 2 different agencies. He's 31, as I indicated, no children. Upon his previous release, he was sponsored by his mother. My client also was District Successful Complete Community Solutions, the Cheney House in Hartford, and he's self-sponsored. As far as employment, he's always had work. He's always had a job where he was out, had a full-time at Paroles Gas in Waterbury. He's indicated to us he can't go back to a job. He's also established his own clothing line, which he had a logo designed, and he's waiting for some t-shirts from the manufacturer. So he is involved in that also. Also worked with, at the time, his girlfriend's family had a carnival. He traveled around the different locations throughout the state, assisted with setting up and running the rides. Had a part-time job as a dishwasher at Eli Cannon's in Middletown, and also obtained his PCA, the personal care assistant job through a company in Hartford. He's also done some treatment. There's some outpatient treatment at Wheeler Clinic when he was with his mother in Bristol. Also had began the process of coordinating the Explore Domestic program in Hartford. And then because of the two agencies, he was not able to start the class, and then he was remanded. Also worked through a Yale research program on mental health, infectious disease in Hartford. And Yale provided him with some resources. They did work with him for approximately 3 months. They do visit him at the facility, so he still is involved with them. As far as a sponsor, he does want to go back with his mother. She was, as I indicated, she was his previous sponsor. As I always advise my clients, as long as things not change, she could be viable sponsor again. I provided you with her address and a phone number, and he will, at some point down the road, he'd like to transfer out of state to live with his family. He's also aware regarding the interstate and the timeline regarding that. He does wish to obtain his GED, and he wishes to study business management for his clothing line. As I indicated, he can return to a full-time job at Paroles Gas. Trevor, anything I left out regarding your background, your job you have lined up? You have your mother in place. And I just want to make sure, once again, I know I'm beating this to death, but the basis of your obedience to the law was the violation of probation, where the allegation was you missed some appointments. You don't have any cases pending in court anywhere. You weren't charged with any new criminal conduct, correct?
Correct.
Okay. Anything else that I put on the record you want to add regarding your background or anything?
No, I think you hit it on the nail, honestly.
Okay. All right. Thank you.
I'm going to take a moment before I announce my recommendation. So I recommend revoke and re-parole on November 14th, 2024, which is an approximate 3-month sanction with the following conditions: no consumption of alcohol, domestic violence, no contact with victims S&W and EM, mental health evaluation, halfway house placement, and no operation of a motor vehicle without the express permission of your parole officer. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on November 14th. The board may let my recommended sanction stand or impose a sanction longer than what I have recommended. If the board chooses to impose a sanction longer than what I have recommended, then a supplemental hearing would be held at that time.
If I may, Trevor, it's going to board review next Thursday, the 14th. If they adopt the recommendation, you are on special parole, correct? According to my notes, you will be released that day. That's how you're going to know if they adopt the recommendation. The board meets in the morning. If your case status is adopted by the board, which hopefully they adopt it, you'll be released next week, that afternoon. If they don't adopt it, as she indicated, I'll have to set up a call with you, and there's another hearing involved. If you're out, that means they adopted it. You're not going to get anything in writing. There's not going to be time. You'll be out before that occurs.
So that means I gotta go to halfway too?
Yeah,
In the event that it's needed.
if it's needed. Your mother is the first choice. If for some reason the circumstances have changed from the last time you were there, they'll stick you in a halfway house to get you out. But if nothing's changed with your mom, hopefully it'll put you back there. Stan?
Yep.
All right, good luck to you.
Thank you. You're all set.
Thank you.
Thank you.
Good morning.
Hi, good morning. How are you?
Good. Is there any way we would be able to get started with Mr. Hayes?
Yep, I have Hayes, Griffin, and Marino here.
Yeah, if we could get started with Hayes, that would be great. And then
Okay.
from Hayes, we could just go back to Mr. Marino.
Marino, okay, and then
Yep.
we'll do Griffin. Okay,
Yeah, okay, thank you.
you're welcome. Hayes, you can come on in.
Good morning.
Good morning.
My name is Officer Saunders. I'm a hearing examiner for the Board of Parties and Paroles. This is a preliminary hearing concerning Kyle Hayes, 324041. Today is Tuesday, November 5th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
Kyle Hayes, MA number 324041.
This is a public hearing. Public access to this hearing is available via video live stream. This is a preliminary hearing which has three purposes under Connecticut law: to determine if there's probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversary proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Hayes, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your officer is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You may hire your own attorney if you cannot afford an attorney. You may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing or proceed without counsel?
Seek counsel.
So you want to, so we're going to, if you want counsel, I'm going to have to continue your hearing so that you could apply for an attorney. And that's fine. I just wanted to make sure you're aware. I'll continue the hearing. My next available hearing is November 19th.
Okay.
Okay, so we'll wait. You're gonna that way. We're going to continue it for today, and then you're going to request an attorney.
Yes.
Okay, thank you. You're all set.
You have a good day.
You as well.
Okay. All right, so.
Good morning, Mr. Marino.
Good morning.
So we're waiting for your attorney. She's in another hearing right now, so it'll probably be about another 10 to 15 minutes before we get started.
Thank you.
Thank you.
Okay. So this one. They're gonna roll it. You go here, neighbor, funny family. And you just hit show the check. And then it looks like who they want. And it's going to back. Just hit start on here. Let me see. Yeah, so you see, there's one there. And you just look for, if that one is not done, you just gonna look for anything. And I will see it. Make sure Thank you. Other than that, it's gonna be a word. Yeah, we just take 20 and that's one. And this one here, I'm gonna start this one. This one is just like the next one. You're okay. But I'm not gonna go anywhere. And that's what-
Good morning.
Good morning.
Morning. Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Brian Marino, 328534. Today is Tuesday, November 5th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
Brian Carl Marino, 328534.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Thank you. Attorney Sonia Jones, Public Defender's Office Parole Revocation Unit on behalf of Mr. Marino.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Marino, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your officers bring against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Thank you. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state your officers bring against you and the information underlying each charge. Charge 1, obedience to the law. On October 16th, 2023, you went to the virtual bank teller at Ion Bank in South Windsor and cashed a fraudulent check against a real estate company, Miller Napatino Wolf LLC, payable to yourself in the amount of $3,277 with a memo, electrical services. On February 2nd, 2024, a warrant was issued on your behalf. On March 27th, 2024, you were subsequently arrested and charged with forgery second, larceny third, property service more than $2,000, and fraudulent use of an automatic teller machine. On July 8th, 2024, you appeared in Manchester Superior Court, GA12, and was convicted of larceny third, property service more than $2,000, and sentenced to 3 years jail, execution suspended after 6 months, and 3 years probation. Based on this information, you are in violation of your standard parole condition, obey all laws. The state has filed the following exhibits. Exhibit A, signed statement of understanding and agreement, conditions of parole. Exhibit B, remand to custody order. Exhibit C, notice of parole violation. Exhibit D, parole violation report. Exhibit E, arrest warrant application and case incident report for South Windsor Police Department ending in 452. Exhibit F, judicial branch criminal motor vehicle conviction detail. Exhibit G, State of Connecticut Board of Pardons and Paroles verification summary. Exhibit H, State of Connecticut Board of Pardons and Paroles written decision form. And Exhibit I, State of Connecticut Board of Pardons and Paroles decision information summary. The state filed an addendum to Exhibit D, which states on July 8th, 2024, Mr. Marino was convicted of larceny third, property service more than $2,000. Mr. Marino was sentenced 3 years jail, execution suspended after 6 months, 3 years probation. The charges of forgery second and fraudulent use of an automatic teller was nollied under docket ending in 097. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes.
Defense has filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Exhibit 2, offender work performance and program refusal form for Tier 4. Defense Exhibit 3, letter from NA sponsor dated 9/11. Exhibit 4, letter from Brian Marino. Exhibit 5, letter from NA sponsor dated October 12th. And Exhibit 6, certificate of achievement from Seacar Recovery Coach Academy. Today we have no witnesses, and it is now the defense opportunity to present evidence that speaks to any of the evidence submitted.
Thank you. I would just indicate in regards to charge 1 under obedience to the law, the addendum is stated accurately that my client has served that 6-month sentence and that was known to all parties at the date of his last hearing, where there was a global disposition between GA 14 Hartford and GA 12 Manchester.
Griffin, I'm gonna have you wait in this room right here, buddy.
I just wanted to just double check the end of sentence date, because I believe it's still running concurrently. So I'm gonna just check.
No, he served that sentence. He he discharged off that sentence. I believe it was October, Brian, it was at the 8th?
No, it was 9/27.
Oh, 9/27. Okay, thank you.
So I have that it's still running concurrently, and the end of sentence is December 23rd, 2024. Just that's per our records, because he was sentenced on July 8th, and it's a 6-month sentence, and so that the max date on that is 12/23/2024, but it's running concurrent to the other charges.
So all I know is on the last date, on his last hearing, that was, he was serving that sentence at the date of his last hearing, which was just a month ago, or less than a month ago. And that it was known to myself, you, as well as the parole officer, and that you gave him a re-parole date of October 10th. And so that was why I was under the impression that the sentence had already been served by that date. But if you're telling me that it's still running, go ahead, Brian.
I gave you a copy of my minimus from the jail where it states that I get credit from 3/27. That's the credit where the credit started. It's on. I sent that to you in the mail. It's a jail minimus.
Yeah, let me just double check.
They have it on file here too.
So let's see, March. Yeah, I mean, he is accurate. Then I do have a copy of his minimus, which indicates that his jail credit went back to 3/27/24, where he was sentenced to 3 years execution suspended after 6 months, 3 years of probation. So that sentence has been served.
Okay, so according to the system, he has no jail credit, but I will mark. Is there any way you can email that, or we can mark it as an exhibit?
I absolutely can. Yes.
Okay.
Yeah,
because it's showing he has no jail credit.
Okay,
for this particular docket, ending in 097.
Yep, and so that is the docket. Okay, so if you want to just give me a moment, I can scan it right now on my phone and then email it to you now, so you can receive it right now.
Okay.
All right, so just give me a moment, please.
And I'm gonna just take a quick recess while you do that.
Yes.
Until he comes, if he's still here. If he comes, we can still here. And then he would go in, yeah. And if he were there, then we do it. Take right. Sure, yes, take it right. So, we're now. Yeah, and they got no names.
Is it working?
Yeah, I'm just waiting for it to go through, the send to go through.
Awesome.
Okay. If we come out, you can. Don't let this guy.
All right.
Attorney Jones, did you send it over yet?
I did. I sent it a couple different ways, so you should get it.
So once we receive documentation, I spoke to my supervisor and we're gonna send an email to records over at Osborn so they can accurately reflect his jail credit.
Okay. I mean, if you think about it, he wouldn't have been able to leave on the date you gave him last time if he hadn't served the sentence. So I'm not sure.
Okay, so while we get that documentation, is there anything further before I announce my findings?
No.
On charge 1, obedience to the law, I make a finding based off of Mr. Marino's conviction as well as states exhibits A, D, E, and F. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Yes, thank you. My client is 58 years of age. He's single. He has no children. He's a high school graduate. He's been in custody now, I believe, for over 13 months, held continuously. This violation based on new criminal conduct where my client received a split sentence, and that disposition was known to the parole officer, the hearing examiner, and defense counsel at the time of his last revocation hearing. And I believe specifically it was taken into consideration in terms of giving him his re-parole date, which was the October 10th date, because he would have served his, as he just indicated, he would have served that court sentence effective as of that September 26th date. It's unfortunate that Mr. Marino has served his court sentence. Again, it was known to everyone at the time of his last revocation hearing, and as the hearing examiner had to take that disposition into consideration, as it directly impacted what the sanction would be since he was serving the 6-month sentence at that time. Mr. Marino has an obligation to make restitution and to the victim of that case, and that obligation is being delayed here by what I would consider a loophole in the parole revocation process that clearly is in need of legislative intervention and revision. It's punitive and against the post admissions of PCS that the parole officer can choose not to include in the parole violation report a case that was pending and a case that resulted in a global disposition in court. And again, that was between GA 14 and GA 12 Manchester. We had requested multiple times that the amendment be made to the parole violation report. We would have consented to that certainly, and that the parole officer can choose not to include that for this very reason, so that when Mr. Marino was due to re-parole, they can just re-violate him again based on conduct that was already known to him. We don't agree with that, but here we are. So I would just point out again, as I pointed out simply less than 4 weeks ago in his last, or a little bit over 4 weeks ago in his last revocation hearing, that while he's been in custody, he has successfully completed the Tier 4 program. He was attending the CCAR Academy 30-hour training to be a coach. And since that last hearing, he has completed that programming. That certification. He's certified by SafeServe for culinary. Aftercare in Department of Corrections includes attending meetings at addiction services. He's been attending NA 3 times weekly. He has completed, I believe, the 7th step, working as a tierman for 7 months at Osborn, has his driver's license, was enrolled in CDL training programming. And upon reinstatement to parole supervision, he plans to volunteer and work with NA. He's eligible to return to his position at Recovery on the Green. Treatment, by way of treatment, he's amenable to all treatment recommendations, including reestablishing clinical services at Wheeler Clinic, as well as working with a 12-step program, continuing to work with that program. In addition, his future plans include attending church, twice weekly at First Baptist Church in Woodbury. He'd like to be sponsored in the Middletown halfway house area, and secondary to that, in the Waterbury area, if that Middletown area were not available. Again, we would just point out that this criminal conviction was known to everybody at the time of his last hearing. It was taken into consideration by way of a global disposition. I think it's unfortunate that my client is back here because the parole officer, after he had served that sentence, chose to reviolate, though they knew about it. I think yourself as the last hearing examiner, it's my belief, and we can go back and watch that hearing if we have to, that disposition was taken into consideration in terms of giving him a sanction, as he could only be sanctioned to a time where he needed to be sanctioned to a time period for his release that corresponded with him having served that 6-month sentence in jail. Otherwise, he would not have been eligible to be released. So I believe that was taken into consideration. And so we would be asking that he be re-paroled immediately. Thank you.
I did receive the minimus, and I, as stated before, my supervisor will be reaching out to DOC to have this accurately reflected in our systems to show that it appears that your sentence has been served. Okay, but I'm going to take a quick recess before I announce my recommendation.
Thank you.
Big issue. And they want to witness, they sold. They had the yeah, but I think like something like that. Yeah. That. So you can't go be there. It's cheap. If somebody can be there, we don't know. Big guy out there. He was like ran out. He was charge the gate of your company trades, chicken trades, rice trades, and I would mind. Yeah, you could give people a cook. That'd be the best way to go. Oh, that would be fine. I mean, looking at the CEOs, maybe I don't know. We don't reach that. I could be fired. I could. That's your. That's it.
Yes. And I do that because I feel like it's great for a lot of people in the data. But thank you. I feel like if you do something more interesting.
Okay, we are now back on the record. So just to make it clear, at Mr. Marino's last revocation hearing held on October 1st, after reviewing the record, I was not aware of this criminal violation. I was only, my 12-month sanction was it from the date of his remand in the state of Massachusetts based off of the behavior and the violation that I was given at that time and testimony that was stated on the record on 10-1. So this behavior was not, I was not aware as the last hearing examiner of this violation based off of the available evidence and testimony given on 10-1.
So what I'm saying is that I believe that you were able to see that he had a sentence that he was serving. And so in consideration of his re-parole date, that sentence was known. I'm not saying that the parole officer submitted anything to indicate that he had that, because they didn't, which is my problem. I have a problem with that because they knew about it. And we asked them to submit it and they didn't. So
Okay.
That is the point I'm making. He was serving a sentence. It wasn't a secret. You could look into Department of Corrections and see he was serving a sentence. That's the point I'm making. So to me, when you have to take into consideration when to re-parole him, knowing he's serving a sentence, even though it wasn't on his parole violation report, to me, that's taking it into consideration because he couldn't have been re-paroled any earlier because he was serving that sentence. That's the point I was making.
But if we don't have to rent it up, what we could sell people and
Good. Just to be clear, so on that, so based off of his parole eligibility date, from what I see, it was 9/22/24. So my recommendation was a 12-month sanction from the date of remand, which was 10/10/24. But I'm taking into consideration everything that was said today. And based off of all of the information and testimony today, I recommend revoke and re-parole on November 14th, 2024, which is an approximate 1-month sanction from his current date of remand. with the following conditions: no consumption of alcohol, a general no contact with Miller Napatino Wolf LLC, halfway house placement, mental health evaluation, and no contact with co-defendants Jose Diaz and Josue Burgos. My findings and recommendations will be forwarded to the board. You will receive the official written decision from the board, and your board review is scheduled on November 14th, 2024. The board may let my recommended sanction stand or impose a sanction longer than what I have recommended. If they choose to go longer than what I have recommended, then a supplemental hearing would be held. And at that time, the specific reason, they would document the specific reasons why they might want to exceed my recommendation. Okay, so November 14th, 2024 is my recommendation, which is a 1 month sanction.
Thank you. We
Okay.
appreciate it. And for some reason, Brian, if you're still in custody after that date, call my office, okay?
All right, thank you both.
All right. Good luck, sir.
Thank you.
God bless.
Thank you, P.O. Saunders.
No problem. And I'm going to wait for Mr. Griffin so you could speak with
Oh,
him. I'll
yeah.
put it on
Yep,
record.
yep.
Are you all set for Mr. Griffin?
Yes.
Okay.
Good morning, Mr. Griffin. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Parole Central Office. This is a preliminary hearing concerning David Griffin, 301-682. Today is Tuesday, November 5th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
David Griffin, 301-682.
This is a public hearing. Public access to this hearing is available via video live stream. Also this morning, I have present as Attorney Jones, who would like to moment to speak with you.
Thank you. Mr. Griffin, you indicated that you wanted the Public Defender's Office to represent you at your hearing, okay? However, we've tried to schedule a legal call with you with your counselor and have not yet been able to schedule that call. So we would need to take your public defender application to determine your eligibility, and then an attorney would need to talk to you about the violation. So if you want representation by our office, my suggestion then would be that you request a continuance today so that our office can take that application from you and have an attorney speak with you. Otherwise, you're welcome to go forward on your own, but that would not be my advice to you. But it's obviously your choice. So what would you like to do, sir?
Oh, yes. I was looking at the violation. This is just a technical, but I guess if I ask for a continuance, that'd be like a 2-week continuance, something.
Yes, my next available hearing date is November 19th.
Okay.
So yes, it's about 2 weeks. Yep.
About 2 weeks?
Yeah, November 19th would be my next available hearing date, if you continue today.
Well, all right. Well, I guess I followed through with the continuing because I was looking at the violation. It was just a technical violation, but
Okay, so if you want our office to
I didn't
represent
mention
you,
the charge. No, because I had got confused a little bit because I thought this was a case where I was charged or something, but this is just a technical. This not. I don't have no charges, so that's why I wanted an attorney. But it's
right. So
I thought,
yeah. So if you want our office to represent you, then we would ask for that November 19th continuance date, and someone from my office will reach out to you. So is that what you would like to do today?
I'll just follow through today.
Okay, so you don't want attorney representation, you want to move forward today?
Yeah.
Okay.
Okay, then I'm gonna sign off and go to the next hearing room. Thank you.
Thank you. This is a preliminary hearing which has 3 purposes under Connecticut law: to determine if there's probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony of today's hearing will be taken under oath. Mr. Griffin, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. You put your hand in. Then we will review the parole violation charge the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will announce you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
No?
No.
Okay. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney, which you chose to move forward without today. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your officer is bringing against you and information underlying each charge. On charge 1, halfway house placement. On October 11th, 2024, you were released from Osborn Correctional Institution on special parole supervision and placed in the Cheney House, halfway house, located in at 155 Weathersfield Avenue, Hartford, Connecticut. During your intake process, you read and signed your halfway house agreement and special parole conditions, indicating you understood the expectations that were placed on you for community supervision. After completing your intake, you informed halfway house staff that you were supposed to / wanted to go to the Open Hearts halfway house. You proceeded to walk out the halfway house without permission from your parole officer or halfway house staff. You left at 1:49 p.m. and returned at 5:20 p.m. Your whereabouts in the community were unknown for approximately 3 hours and 31 minutes. You are in violation of your halfway house agreement, which states, I will not leave the physical confines of the halfway house unless authorized by program staff or parole. On October 13th, 2024, you came to staff office at 4:40 p.m. to return the house cordless phone and stated, I'm not going to lie, I'm leaving. You proceeded to leave the halfway house without permission from halfway house staff or parole. You returned to the halfway house at 11:28 p.m. Your whereabouts in the community were unknown for 6 hours and 48 minutes. You are in violation of your halfway house agreement, which states, I will not leave the physical confines of the halfway house unless authorized by program staff or parole. On October 15th, 2024, you voluntarily walked out of the halfway house at 2:20 p.m. with a bag in your hand. Halfway house staff tried to call you back into the building. You replied to staff by saying, I'm gone, I'm not coming back. You are in violation of your halfway house agreement, which states, I will not leave the physical confines of the halfway house unless authorized by program staff or parole. The state has filed the following exhibits. Exhibit A, remand to actual custody. Exhibit B, parole conditions. Exhibit C, halfway house agreement. Exhibit D, notice of parole violation. Exhibit E, notice of parolee rights. Exhibit F, parole violation report. Exhibit G, halfway house incident report ×2. Exhibit H, halfway house incident report dated 10/13/24. Exhibit I, halfway house incident report dated 10/15/24. Exhibit J, misconduct reports dated 10/11, 10/12, and 10/13. Exhibit K, revocation hearing summary dated 5/17/23, December 20th, 2023, and May 3rd, 2024. Exhibit L, Hartford police report dated 10/23/24. Mr. Griffin, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Before I discharged the last time?
No,
Yeah.
this time. You should have received an evidence packet where this current
Yeah,
violation.
Yes,
You
yes,
have it.
yes. I haven't.
So today we have no witnesses, and it is now your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. Would you like to respond to the charges at this time?
But, before this halfway house, it was a few other violations I had, but there was all like halfway houses for violations for me walking away, but I was having problems in that halfway house, and I think the furthest thing was for me, even though it was a wrong decision, to remove myself at that time. And I kept talking to the staff about it because I'm not trying to come back to jail for no charges or no other charges in the community no more. I've been incarcerated for a long time, and it seems like I can't stay in the community for, every time there's these halfway houses that they're putting me in, and a bunch of things is going on, but I wasn't doing that purposely just to, just act belligerent and just be out in the community doing things or anything. I just felt like the stuff I was talking to the staff about in the halfway house that was going on in there when the birds got there, it seemed like they were just brushing that off. And me and my background history, I have a long history of things, so I know it was wrong for me for walking away. As for that charge, for that absconding charge, but I just feel like the staff wasn't trying to hear me. And then at the last minute, I was going on Open Heart, and they switched me to Cheney House on Weathersfield Avenue. Like I didn't understand that when that area is no good for me at all. And I know that I was trying to talk to the staff, kept trying to talk to the staff, and I just felt like they wasn't really trying to hear me out and stuff. That's why I kept coming back, multiple times when I left, because I really wanted to work with them, stuff like that. But I just felt like why was I switched from Open Heart to Cheney House? And I just didn't get that. I was trying to make really on this role a positive change. I just didn't want to be around that area. And they know that, like, all my years in Hartford, and I know I went about it wrong from walking away, but it's times that I come back because, I was thinking more this time, I know it's gonna hurt me, not everybody. At the end of the day, it's gonna hurt me, and I know I have months now to discharge, but which I could have helped myself on special parole is using the programs and different things that they provided me with. It seems like I didn't even get that yet, and that's bad. So the decisions that I was making was wrong for walking away and stuff like that. I just didn't want to go through the same processes before of setting myself up for failure when there's something's going on inside a halfway house and staying there and not saying nothing and just going through it and catching more charges. I didn't want to do that no more. So that was part of me, just kept walking away. Then I'll come back to the halfway house. Then I'll walk away again. I'll talk to the staff. I'll come back to the halfway house and stuff going on. And I just felt like they wasn't really concerned, just brushing it off, but.
Anything further before I announce my findings?
Yeah, and look, like I said, this, I know it was a poor decision to do that, but it's just, I was trying to make it work in the Cheney House. It's just that certain staff, I don't understand that when you got all these case managers in there that could really help you. And when you sit down and you talk to them, it's like they don't really want to hear you out. They act like they really want to hear you. And I've been through this process so many times before and stuff like that. So when I'm thinking about everything, like my stableness in the community, as for one, just everything, like me just having a roof over my head, me having a job, stuff, mental health therapy, all these things I had to get through. But I seem like they're placing me in places with other people where when they switch me like that, where that these people and me doesn't see, and it's like you put me in these situations and a better way to go about it. It's like, even though I could have stayed and then talked to another case manager about the situation, because I had went to my brother's house and I was there, which was in the report. I had went to my brother's house and I guess a call was made, but basically he was confused, it wasn't no charges pressed or none, but he was like, I don't understand that, off your past, I was just reading my package. And back in like 2010, I got arrested for a firearm once, but it says that I was known to carry that, and I never had been arrested for that multiple times. Like, I don't know where that came from. Like, it's like they was just like automatically, like the police said in the report, I was known to that. And I could see if I was, multiple in a community constantly committing them acts, but which is not true because you could look at my history. So I'm like, where's that coming? Like, they already profiling me before I get out there, and you're placing me in places where I'm a clash out and there's people there I don't post, and I'm trying to work with the situation, dealing with everything going on with me and my family, my mental health situation, and everything I gotta do and stuff. And when I get out there, it's just me basically trying to help myself. So when I see myself in this situation and stuff like that, instead of using the old way and doing stuff and catching charges, I'd rather just walk away from the situation. And I know it was wrong for me leaving that halfway house like that. And, but as you can see, I came back multiple times and I was talking to them and I tried to call somebody, but it seemed like I wasn't getting through to them like they didn't care. So instead of me making a real criminal wild act of doing anything, I'd rather just walk away from the situation.
Okay. Anything further before I announce my findings? Thank you.
Thank you.
On charge 1, halfway house placement, I make a finding of probable cause based off of your testimony today, as well as states exhibits B, C, and F through J. Now, Mr. Griffin, being that you were out in the community for only 12 days after being, released from a previous violation, I do find that these acts are serious enough to warrant revocation. And I have also determined that you should be detained while you wait for your revocation hearing, okay? Your revocation hearing will be scheduled within 60 business days from the day that you return back into custody. You will receive a hearing disposition, which will have a tentative hearing date listed. And keep in mind, all hearing dates are subject to change. At the revocation hearing, a hearing examiner will determine if you violated the conditions of your parole. And if so, the hearing examiner will make a recommendation regarding whether your parole should be revoked. Okay, so this does conclude your preliminary hearing, and thank you. Thank you. So we're all set.
Yeah.
You can leave it on the desk.
Yeah, you don't need that.
Hi, good afternoon, or we're still morning. Hi.
Hello. Hello. Give us 1 second. He's walking in.
Where are you from?
What's it on there? You're waiting for, what's the offender's last name?
Only Nichols. We don't need Thompson. He waived, so he will not be seen today. So we only need Nichols.
Nichols? Okay.
Yep.
1 second.
If he's still down here, I got you. I'll write it down.
All right.
Hello.
No.
Oh, good morning.
Morning.
So don't worry about that. And anything I'll put him on now. If he's still here, I'll go with it, okay? All right.
My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Julius Nichols, 260191. Today is Tuesday, November 5th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in New Haven Correctional Center. Please state your full name and DOC inmate number for the record.
Julius Nichols, 260191.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Hi, Hannah Dean, for the record on behalf of Mr. Nichols.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on full supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Nichols, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read your rights. Then we will review the parole violation charges that the state, your parole officers, bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
Thank you. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
Okay. We now will review the charges that the state, your parole officers, bringing against you and the information underlying each charge. Charge 1, obedience to the law. On August 8th, 2024, at approximately 8:38 p.m., you were arrested by New Haven Police Department for the following charges: breach of peace 2nd, criminal mischief 3rd, robbery 3rd, and interference with an officer. Said charges came from you approaching a female bystander at the bus stop and asking her for a Lucy, aka loose cigarette. She gave you one, but you insisted on multiple, in which she declined. You then grabbed her purse, pulling it from her shoulder and tearing the strap in the process. Throughout the encounter, you threatened to cut her and kill her if she didn't stop resisting. Several bystanders had to chase you away. You then boarded the city bus afterwards. Police were able to locate the city bus and you by the description given to them by your victim. You impeded the officers' investigation by stating you were homeless and stating your name was Tariq Smith, date of birth 10/3/81, and you could not recall any previous addresses you lived at. Arresting officer brought you back to be identified by the victim, who confirmed you as her mother. Arresting officer later found your state of Connecticut driver's license in your pocket and correctly identified you as Julius Nichols, date of birth 10/3/80. Charge 2, drugs. On or about August 4th, 2024, you tested positive for cocaine. On or about August 8th, 2024, you tested positive for cocaine. Charge 3, behavioral management program. On June 14th, 2024, P.O. Shep completed an Explore referral per your stipulated special parole conditions to participate in behavioral management program for domestic violence. You completed your intake on June 20th, 2024 at Willow Clinic located at 43 Woodland Street in Hartford, Connecticut. Your first session was on July 8th, 2024. You failed to attend DV group on 7/15/24, and you missed your session on August 7th, 2024. You only completed 2 sessions to date. You were originally scheduled to attend treatment every Monday at 7:30 p.m. You asked your schedule to change on or about July 29th, 2024, so you could complete flagging certification for your job. Your request was granted on July 30th, 2024, and you were switched to Wednesdays at 12:30 p.m. On August 12th, 2024, you were discharged unsuccessfully due to your incarceration at Hartford Correctional Center, or New Haven Correctional Center. And charge 4, halfway house placement. On July 1st, 2024, you were placed at Cheney Halfway House, where you reviewed and signed your special parole condition and halfway house agreement. On July 11th, 2024, you started a heated argument with your roommate over getting ready for work in the morning. You were upset that your roommate's alarm for work woke you up. When your roommate tried to go to the bathroom, you rushed into the bathroom before him. You further got upset when your roommate turned the lights on, which was on his side of the room. Your roommate informed you he was getting ready for work. You responded, "Don't act like you're better than me. You're just another N-word with a job." Your roommate informed you not to be disrespectful, and more words were exchanged between both of you. You then informed your roommate, "I will beat your ass. You are in violation of your halfway house agreement, which states, I will treat others with respect and not engage in any verbal or physical altercations with other offenders, staff, or third parties." On August 2nd, 2024, you were given a pass to attend your school program at Best Chance. You were given a return time of 4 p.m. in order to sign back out for work. You did not return to the halfway house at 4 p.m. When staff contacted you to inquire about your whereabouts, you reported you were on your way to CSI/halfway house. Staff reported you should have been at work already since you didn't return to sign out. You reported, "Oh yeah, I'm on my way to the bus to work." Staff reminded you that you work at Sardelli's and not CSI. You agreed and continued to state you were on your way to work. Halfway house contacted your employer, and they reported you were terminated for being under the influence of an unknown substance on August 1st, 2024. Staff called you at 6:13 p.m. and requested for your return to the halfway house by 6:30 p.m. You reported that was not enough time and you would be back by 7 p.m. You eventually returned to the halfway house at 7:56 p.m. Your whereabouts in the community were unknown for about 3 hours and 56 minutes. You are in violation of your halfway house agreement, which states, "I will only go to the locations indicated on an approved community pass unless changes have been authorized by staff." On August 8th, 2024, halfway house staff notified this PL that you appeared to be under the influence. Instant urinalysis was given to you. You provided a specimen sample, which was positive for cocaine. Halfway house staff placed you on no movement. You called my work cell shortly after being asked to be able to go to a job interview due to being on no movement. This PO informed you, "I was en route to the halfway house to speak with you." Upon arriving to the halfway house, you were lifting weights in the weight room. This PO went to speak with program director regarding your test and completing a referral to the App Foundation for you. Instead of meeting with this PO, you voluntarily ran out of the back door of the halfway house. You left the halfway house without an approved written pass from the halfway house. Your only approved parole and community services residence was the halfway house located at 155 Weathersfield Avenue, Hartford, Connecticut. You are in violation of your halfway house agreement, which states, I will not leave the physical confines of the halfway house unless authorized by program staff or parole." The state has filed the following exhibits. Exhibit A, remand to actual custody order. Exhibit B, parole conditions. Exhibit C, halfway house agreement. Exhibit D, notice of parole violation. Exhibit E, notice of parolee rights. Exhibit F, parole violation report. Exhibit G, incident report dated July 11th, 2024. Exhibit H, offender's written statement dated 7/12/24. Exhibit I, offender misconduct dated July 18th, 2024. Exhibit J, incident report dated August 2nd, 2024. Exhibit K, offender misconduct report dated August 3rd, 2024. Exhibit L, incident report dated August 4th, 2024. Exhibit M, Redwood toxology report dated 8/4/24. Exhibit N, incident report dated 8/5/2024. Exhibit O, offender misconduct dated 8/5/24. Exhibit P, disciplinary action report dated August 7th, 2024. Exhibit Q, offender misconduct report dated 8/7/24. Exhibit R, incident report dated 8/8/24. Exhibit S, offender misconduct report dated August 8th, 2024. Exhibit T, emails from Miller Clinic. Exhibit U, picture of offender in weight room and running out of the halfway house. Exhibit V, New Haven Police Report. Exhibit W, CT Judicial Branch pending case detail. And Exhibit X, Explore Discharge Report, Miller Clinic. The state has filed an addendum to Exhibit F, which states on October 10th, 2024, Mr. Nichols was found guilty of breach of peace second and criminal mischief third and was sentenced to 6 months jail, execution suspended after 1 year conditional discharge. The charges of robbery third and interference with an officer was now laid under docket ending in 404. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes, I have.
And defense has also filed Exhibit 1, parole accomplishments for future plans for parole reinstatement. Today, we have no witnesses, and it is now the defense opportunity for the evidence to speak to any of the evidence submitted.
Thank you very much. As to the first charge, obedience to the law, I don't have any comments as to the preponderance standard, but I did just want to clarify that is accurate, the addendum that was read. He did not receive any time to serve. He got a fully suspended sentence with just 1 year of conditional discharge, and the more serious charges were nollied. He pleaded under the Alford Doctrine to 2 B misdemeanors, so the lower level charges of what he was charged with. As to the second charge of drugs, I would argue that the preponderance standard has not been met. The allegations in the PBR are that on 8/4/24 and 8/8/24, Mr. Nichols tested positive for cocaine. However, the evidence is insufficient as to the allegation of 8/8/24. Exhibit S is the evidence that was submitted for that charge, which indicates that the client tested positive for cocaine, but there are no associated drug screens or toxicology reports to indicate that that specific incident was a confirmed positive. So I would argue for that charge that the burden has not been met and there should not be a finding. As to the third charge, behavioral management program, specifically Explore, I would argue that the preponderance standard has not been met. This was not an intentional violation. My client did follow the instructions provided to him by program staff. In this case, my client had received some conflicting information regarding when the required DB groups will be available. As indicated, he had previously been attending them at Mondays at 7:30 p.m. However, this conflicted with his schooling, so he was given a different date and time to report. Mr. Nichols, if I could just ask you a couple questions about that while you're under oath. So you were moved from the Monday at 7:30 Explore group to a Wednesday group at 12:30 p.m. Is that accurate?
Yes.
Thank you. And the first time that you were required to report to that 12:30 p.m. Wednesday class and you got there to Wheeler Clinic, what did the staff tell you?
They told me that there was no 12:30 class, that it was at 10:30 a.m.
Thank you very much. So as my client indicated, when he did get to the program at the time that he was told to report there, he spoke to Wheeler Clinic staff who did indicate to him that he was not there for, there weren't groups available for him that he needed at that time. So I think that this was more of a misunderstanding than an intentional violation. I think that he was given conflicting information to no fault of his own. So for that, I would just ask that there be no finding. And as to the fourth charge, I have no comments as to the preponderance standard. And at the appropriate time, I would just like to make some comments regarding his future plans for parole and prior accomplishments. Thank you very much.
Thank you. I'm just going to take a moment before I announce my findings. Yes. And we're back on the record. On charge 1, obedience to law, I make a finding based off of Mr. Nichols' conviction, as well as states exhibits B, F, V, and W. On charge 2, drugs, I make a finding based on states exhibits B, F, L, M, and S. On charge 3, behavior management program, I make a no finding as the state failed to provide sufficient evidence to prove that Mr. Nichols' actions meet the elements of this charge. And on charge 4, halfway house placement, I make a finding based on state's exhibits B, C, K through F through K, N, and R. That concludes the fact and finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Thank you very much. Mr. Nichols is 44 years old. He receives support from his father, daughter, and some close friends. He has 2 daughters. One is 26 years old, residing out of state. The other is 9 years old and does live here in Connecticut. Mr. Nichols was previously self-sponsored in the community at an independent residence. Unfortunately, to no fault of his own, he fell on hard times and had some difficulty making the rent payments, but he did do his part to work with CRT and some community resources in order to get funding for rental assistance. Nevertheless, unfortunately, his landlord, who he was renting from at that point, was unable to, or unwilling and unable, I believe, to continue waiting for that CRT assistance to come in, and unfortunately did not hold the apartment for my client. When he, at that point, was required to find alternative housing, he then transferred to the halfway house, Cheney House in this case. While at Cheney House, Mr. Nichols did do a number of positive things while in the community. He was engaged in the Capital Workforce Partners Best Chance for a Second Chance program in Hartford, where he was involved in the carpentry program and successfully completed the OSHA 10 program. And he also obtained certifications in scaffolding, flagging, and forklift operation. He was also gainfully employed at Sardilli's Produce and Dairy Company and was doing landscaping for Yard Angels. He also was doing IOP and case management services at CRT in Hartford during this time. Since his remand and incarceration, Mr. Nichols reached out to engage in programming at New Haven Correctional. Specifically, he was wanting to engage in NA and employment services. He also has been attending church there during his incarceration as well. Going forward, my client would like to parole to a halfway house or a sober house so that he is able to get on his, best foot to eventually obtain independent housing. He intends to continue working with CRT to try and gain housing assistance. He also wants to return to the Capital Workforce Partners Best Chance program so that he can attend school. Specifically, he's wanting to do some studying of culinary arts, carpentry, and CNC manufacturing. He's also eventually hoping to obtain long-term employment with those skills and through working with Capital Workforce. In the interim, he intends to return to Sardilli's in Hartford, and my client does want it to be clear that he's very amenable to any sort of treatment that he's asked to participate in, and he's looking forward to re-engaging with CRT for IOP services, case management, and also Wheeler Clinic for the Explore program. I would just request that if there is the decision to revoke parole, that he be given the soonest re-parole date so that he can get back into the community, establish services, and continue doing those positive things he was doing. Thank you very much.
Thank you. I'm going to just take a moment before I make my recommendation. Mr. Nichols, this is your third opportunity since 2021, since your discharge to special parole, that you've been given. This is your second criminal violation, and you were in the community for this time for 2.5 months. And within that time frame, you accrued a new conviction, tested positive for cocaine, you left the halfway house without permission, and you received 6 misconducts.
Miss, can I say something, miss? No, I'm sorry.
I would just advise you, Mr. Nichols, not to say anything specifically about any of the criminal allegations, but if you want to talk to something else, that's fine. Just know that everything you're saying is being recorded and you are under oath still.
Yeah, no, I was just saying that I was self-sponsored since last November 2023. I have my own apartment. I've been in the community since then. She sent me back to do a timeout program for 2 months. But I still had the apartment when I came out, the timeout program. I still have my own apartment since then.
Right. So taking that into consideration, this still is your third opportunity, right? Being on supervision, because you had 1 year of, you served a 1 year criminal violation, then you were out, and then you came back for the top program, and then you were out again. So this is your third opportunity since being discharged to special parole since 2021. So with all that taken into consideration, I recommend revoke and re-parole on February 4th, 2026, which is an approximate 18-month sanction. With the following conditions: no consumption of alcohol, domestic violence, anger management, no contact with victims JC and TR, halfway house placement, and mental health treatment. Now, my findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on November 14th, 2024. Now, on November 14th, 2024, the board is going to take a look at your case. They can lessen my recommended sanction. They can let my recommended sanction stand, or they can exceed my recommendation, being that you're on supervision until 2031. If the board decides to impose a sanction longer than what I have recommended, then a supplemental hearing will be held. And before that hearing, the board will provide you with written notice documenting the specific reasons why they might want to exceed my recommendation. Okay, so again, that's my recommendation, but on November 14th, the board will have the final decision.
And I will touch base with you to let you know what the board does determine, and we can also debrief the hearing and everything at that point.
Okay,
Thank you, Mr. Nichols. This does conclude your revocation hearing.
right, thank you.
Thank you.
Thank you very much.
All right.
And Joshua Thompson, number 337041, waived his preliminary hearing and will not be held, and his hearing will not be held today. Hi, good afternoon.
Hi, how you doing?
Good. You have Mr. Serrano?
He's on his way.
Awesome, thank you.
You're welcome. Thanks, buddy. Got that shirt.
Good afternoon, Mr. Serrano.
Good afternoon.
I'm waiting for your attorney. So once he's available, we'll get started.
All right, thank you.
Thank you. Good afternoon, Liza Rivera. Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that you will faithfully discharge, according to law, your duties as an interpreter to your best ability, so help you God, or upon penalty of perjury? I do. Thank you. Good afternoon. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Hector Serrano, 151103. Today is Tuesday, November 5th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office at MacDougall Correctional Institution.
Buenas tardes, soy la oficial Saunders, examinadora de audiencias para la Junta de Indultos y Libertad Condicional. Esta es una audiencia de revocación referente a Hector Serrano, número 151103. Hoy es 5 de noviembre del 2024. Esta audiencia se está llevando a cabo a través de video en la Junta de Indultos y Libertad Condicional, localidad central, y el Centro Institucional de MacDougall.
Please state your full name and DOC inmate number for the record.
Favor decir su nombre completo, el número de confinado de DOC para el registro.
Hector Serrano, 151103.
This is a public hearing. Public access to this hearing is available via video live stream. Also present this afternoon is your attorney.
Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit, on behalf of Mr. Serrano.
Esta es una audiencia pública. Acceso público a esta audiencia está disponible vía transmisión en vivo. También está presente la defensa, el abogado, el señor Alfonso Sirica, defensor público de la Unidad de Revocación de Libertad Condicional.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement.
Esta es una audiencia de revocación para determinar si ha violado las condiciones de su liberación. Revisaré y haré hallazgos de hecho en cada uno de los cargos en su contra. El Estado, no usted, tiene la responsabilidad de probar las acusaciones mediante una preponderancia de evidencia. Es decir, la mejor evidencia o más pesada debe establecer que, más probable que no, la alegación es cierta. Si no encuentro que haya una preponderancia de evidencia que respalde una violación de una o más de las condiciones de su libertad condicional, restableceré su libertad condicional, lo que significa liberarlo y ponerlo nuevamente en supervisión. Si encuentro que ha violado una o más de las condiciones de su libertad condicional, consideraré si su libertad condicional debe ser revocada o no. Si recomiendo la revocación, haré una recomendación en cuanto a una sanción apropiada. Mi recomendación se dará a un panel para una decisión final. Si el panel desea imponer una sanción más allá de mi recomendación, se proporcionará una audiencia suplementaria para justificar un confinamiento adicional.
The testimony at today's hearing will be taken under oath. Mr. Serrano, please raise your right hand.
El testimonio del día de hoy se estará tomando bajo juramento. Mr. Serrano, a favor, levantar su mano derecha.
Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Usted jura solemnemente y sinceramente afirma, según sea el caso, que la evidencia provista en relación a este caso será la verdad, toda la verdad, nada más que la verdad, y así lo ayude Dios o bajo penalidad de perjurio.
Sí.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your officers bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
Primero voy a leer sus derechos, luego revisaré los cargos de violación que el Estado o el oficial de libertad condicional ha presentado en su contra. Luego revisaré e identificaré la evidencia presentada para el registro. La defensa tendrá la oportunidad de presentar testimonio relevante sujeto a contrainterrogatorio. Luego de considerar toda la evidencia presentada, anunciaré mis hallazgos. Si encuentro que usted ha violado una o más de las condiciones de su libertad condicional, la defensa tendrá oportunidad de hablar acerca de sus antecedentes e historial. ¿Tiene alguna pregunta antes de comenzar?
No.
You have important rights of this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Voy a leer los derechos. Usted tiene derechos importantes en esta audiencia. Tiene derecho a ser representado por un abogado. Tiene derecho a recibir notificación por escrito de los cargos de la violación. Tiene el derecho a revisar la evidencia en su contra antes de esta audiencia. Tiene derecho a presentar pruebas en apoyo de su caso. En esta audiencia usted tiene el derecho de llamar a interrogar a testigos voluntarios y de interrogar a testigos adversos. ¿Entiende usted estos derechos y está listo hacia seguir adelante?
Sí.
Yes.
We now will review the charges of the state your officers bringing against you and the information underlying each charge. Just go straight look. Charge 1, obedience to the law. On August 13th, 2024, Parole conducted an unannounced compliance check at the Open Hearth Halfway House in collaboration with the Connecticut DOC K-9 unit. Located behind your locker in your assigned single occupancy room, the K-9 dog alerted on your locker. The DOC K-9 officer then located a large quantity of marijuana, specifically approximately 12 single package baggies of marijuana, a Ziploc bag filled with marijuana, and also a roll of baggies. Troop H was called to investigate. As a result, you were subsequently arrested and charged with violation, Connecticut General Statute 21A 279A1, possession of controlled substance first offense. Based on your arrest, this places you in clear and direct violation of your signed parole conditions, specifically under obey all laws, as you engage in an act which is a crime.
Ahora voy a estar leyendo los cargos que el oficial ha presentado en su contra. En el cargo número 1, obediencia a la ley, condición de obedecer todas las leyes. El 13 de agosto del 2024, Libertad Condicional llevó a cabo una verificación de cumplimiento en Open Heart Halfway House en colaboración con la unidad K9 de DOC. Localizado detrás de su casillero en su habitación asignada de ocupación individual, el perro de K9 alertó en su casillero. El oficial de K9 de DOC localizó entonces una gran cantidad de marihuana, específicamente aproximadamente 12 bolsitas individuales empacadas de marihuana, una bolsa Ziploc llena de marihuana y también un rollo de bolsitas. La tropa H fue llamada para investigar. Como resultado, usted fue subsecuentemente arrestado y acosado con una violación de Estatuto General de Connecticut 21A-279A1, posesión de sustancia controlada, primera ofensa. Basado en su arresto, esto lo coloca en clara y directa violación a sus condiciones de libertad condicional firmadas, específicamente bajo obedecer todas las leyes, ya que usted se involucró en un acto el cual es un crimen.
Charge 2, halfway house placement. On August 13, 2024, Parole conducted an unannounced compliance check at the Open Hearth Halfway House in collaboration with the Connecticut DOC K-9 unit. Located behind your locker in your assigned single occupancy room, a DOC K-9 officer located approximately 12 single package baggies of marijuana, a Ziploc bag filled with marijuana, and a roll of baggies after the K-9 dog alerted on your locker. This places you in clear and direct violation of your signed parole conditions, specifically under halfway house placement, as you violated a rule in your signed halfway house agreement where it states, I will not consume or possess alcohol or marijuana in the halfway house. On August 13th, 2024, upon parole conducting a pat search of your person and wallet, parole located 2 unopened Suboxone strips in your possession. Although you are prescribed Suboxone, you were clearly not taking the Suboxone as prescribed. This places you in clear and direct violation of your signed parole conditions, specifically under halfway house placement, as you violated a rule in your signed halfway house agreement, where it states, I will take all prescribed medications as directed. On August 13th, 2024, upon parole conducting a pat search of your person, $651 was located in your wallet. This places you in clear and direct violation of your signed parole conditions, specifically under halfway house placement, as you violated a rule in your signed halfway house agreement, where it states, I will not have more than $50 in my possession without prior permission. You did not have permission from anyone to have more than $50 on your person.
Cargo número 2, ubicación en Halfway House. En agosto 13 del 2024, Libertad Condicional llevó a cabo una verificación de cumplimiento en Open Heart Halfway House en colaboración con la unidad de K9 de DOC, localizado detrás de su casillero en su habitación asignada de ocupación individual. Un oficial de K9 de DOC localizó aproximadamente 12 bolsitas individuales empacadas de marihuana, una bolsa Ziploc llena de marihuana y un rollo de bolsitas, luego que el perro K9 alertara en su casillero. Esto lo coloca en clara y directa violación de sus condiciones firmadas de libertad condicional, específicamente bajo ubicación en Halfway House, ya que usted violó una regla en su acuerdo del Halfway House, el cual indica, no consumiré o poseeré alcohol o marihuana en el Halfway House. El 13 de agosto del 2024, a libertad condicional realizar una búsqueda en su persona y su billetera, localizaron 2 tiras de Suboxone en su posesión. A pesar de que usted tiene receta para Suboxone, usted claramente no estaba tomando según recetado. Esto lo coloca en clara y directa violación de sus condiciones firmadas de libertad condicional, específicamente bajo ubicación en Halfway House, ya que usted violó una regla de su acuerdo del Halfway House firmado, donde indica, yo me tomaré todos los medicamentos según indicado. El 13 de agosto del 2024, a libertad condicional, realizar una búsqueda en su persona, $651 fueron encontrados en su billetera. Esto lo coloca en clara y directa violación de sus condiciones de libertad condicional firmadas específicamente bajo ubicación en Halfway House, ya que usted violó una regla en su acuerdo firmado donde indica: yo no tendré más de $50 en mi posesión sin autorización previa. Usted no tenía permiso de ninguna persona para tener más de $50 en su persona.
The state has filed the following exhibits. Exhibit A, PCS conditions. Exhibit B, halfway house agreement. Exhibit C, open hearth incident report. Exhibit D, photos of THC ×2. Exhibit E, police report ending in 118. Exhibit F, copy of summons. Exhibit G, canine officer supplemental incident report. Exhibit H, judicial branch pending case detail. Exhibit I, remand to custody order. Exhibit J, notice of parole violation. Exhibit K, parolee rights. And Exhibit L, parole violation report.
El Estado ha provisto la siguiente evidencia para fines de identificación: exhibición A, condiciones de libertad condicional firmadas; exhibición B, acuerdo de Halfway House; exhibición C, reporte de incidente de Open Heart; exhibición D, fotos de THC; exhibición E, reporte policíaco, finalizando en 118; exhibición F, copia de citación; exhibición G, reporte de incidente suplementario del oficial de K9; H, detalle de caso pendiente de la rama judicial; exhibición I, orden de regreso a custodia; exhibición J, aviso de violación a libertad condicional; exhibición K, derechos de persona en libertad condicional; y exhibición L, reporte de violación a libertad condicional.
The state has filed an addendum to Exhibit L, which states on September 20th, 2024, Mr. Serrano appeared at GA 14 Hartford under docket number ending in 670. The charge, possession of controlled substance first, offense was nollied. Counsel, did you receive the notice of parole violation? Parole violation report and other documents that were marked for identification purposes?
I did.
El Estado ha sometido un anexo a la exhibición L, el cual indica que el 20 de septiembre del 2024, Mr. Serrano compareció ante GA14 en Hartford bajo el expediente, el cual culmina en 65670. El cargo de posesión de sustancias controladas en primera ofensa fue anulado o nullied. A la defensa recibieron el aviso de libertad condicional, reporte de violación a la libertad condicional y los otros documentados que fueron marcados por propósitos de identificación.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Yes. If I may, you did put the correct addendum on the record. My client was arrested on August 13th, 2024, and the charge was nollied in court on September 20th of 2024. Obviously, he was not convicted of anything.
Usted mencionó en el anexo que mi cliente fue arrestado el 13 de agosto del 2024 y este caso fue anulado o nullied en el 20 de septiembre del 2024, lo que significa que él no fue acusado de nada.
And as I routinely put it on the record at these hearings, just because you're arrested by the police doesn't necessarily mean you did what the police claim you did. And this is a prime example. Clearly, the state could not meet its burden, in my opinion, thus the charges were nollied. The charge, singular charge.
Y como ya he dicho anteriormente en estas audiencias, no necesariamente porque la policía te arreste o te acuse de algo significa que tú cometiste este hecho, este acto, y el Estado falló en probar que mi cliente cometió estos hechos.
If I may address the technical violations under halfway house placement.
En relación a la violación técnica bajo ubicación en Halfway House.
And my client was scheduled for a preliminary hearing on August 30th of 2024. And that preliminary hearing was waived because of the pending charge in court.
Mi cliente estaba programado a tener una audiencia preliminar el 30 de agosto del 2024, pero esta audiencia preliminar no se llevó a cabo ya que él tenía casos pendientes en corte.
And this is important, in my opinion, for this hearing. I spoke to my client on August 23rd of 2024, and we talked about the charge, and we talked about the obedience to the law charge, and obviously we talked about charge number 2 under halfway house placement. The first technical violation regarding the narcotics that were found, I'm going to stick to my comments regarding what the disposition in court was. The part 2, I'll label it 2, where he was found in possession of 2 Suboxone strips. I spoke to my client, as I indicated, on August 23rd, and I believe it is in the documents. He is prescribed Suboxone. He did. Mr. Serrano, I'm going to ask you some questions. I think it's better if it comes through your testimony.
Ah,
Yeah, go ahead. I'm trying to keep it succinct. Go ahead, please. I'm sorry.
Entiendo que es importante que mencione esta parte, ya que yo hablé con mi cliente el 23 de agosto del 2024. Nosotros tuvimos una conversación en referencia a este cargo de obediencia a la ley bajo ubicación en Halfway House. En referencia a este caso, no voy a comentar más nada acerca de lo que fue la disposición de corte. En la parte número 2, que es la violación de narcóticos, mi cliente sí tenía unas tiras de Suboxone, según conversé con él el 23 de agosto, pero él sí está recetado y en este momento me gustaría hacerle unas preguntas porque creo que es mejor que él haga ciertas, aclare por su cuenta.
Okay, so Hector, you have a valid medical prescription for Suboxone, correct?
Héctor, ¿usted tiene una receta válida para Suboxone?
Sí, sí.
Right. On August 13th, you were given, on August 13th, when they patted you down, you had 2 strips on you, correct?
Yes. Sí.
Okay. When were those 2 strips given to you?
Por la mañana. Por la
What day?
mañana.
I'm sorry, go ahead.
In the morning.
In the morning.
Okay, on morning of which day?
¿Qué día?
Ese mismo día, el mismo día que me arrestaron.
The same day that I was arrested.
August 13th of 2024.
Sí.
So the morning, and this has got to come through you, this is not my testimony. On August 13th of 2024, in the morning, you were given 2 prescription Suboxone strips, correct?
Yes. Yes.
Okay, could you tell through your testimony, why didn't you take them when they gave them to you in the morning?
Porque usted no se las tomó cuando se las dieron en la mañana.
No me sentía bien, era. No me sentía bien.
Okay, so you didn't take those strips, which it was a valid prescription at the moment they gave them to you because you weren't feeling well, correct?
Sí, dile que tenía un dolor de cabeza demasiado.
I just wanted to say that I had a very strong headache.
Okay.
Yeah, you said you had a headache?
Very strong headache.
You didn't take them because you had a headache. What's important to me, anyway, is those strips were given to you that morning. Those weren't from the day before, the week before, the month before. They were given to you that morning, correct?
Yes, sí,
okay.
Yes.
Okay. All right. One, with the part 3 regarding the money. I know there is some undertone here of my client selling the marijuana packaging for drugs. And sometimes, as I previously indicated, I spoke to my client on August 23rd, okay, of 2024, and went over obviously all the charges. And he's aware regarding the $50, how much money he should have. He was working there, and he had indicated to me about get paid and cashing a check. And family member, I believe it was a sister, giving him approximately, he didn't recall the exact amount, somewhere about $270 is what he told me. Can you interpret that, please?
Voy a hablar acerca de la parte 3 en cuanto se relaciona a la parte del dinero. Creo que hay como un tono que indica que mi cliente tenía estos paquetes porque los estaba utilizando para vender droga. Yo hablé con él, como mencioné anteriormente, el 23 de agosto del 2024. Nosotros fuimos hablamos acerca de los cargos y él está al tanto de que solamente debe tener $50 en efectivo, pero también conversamos que le acababan de pagar y él había cambiado su cheque.
Okay, so this conversation with Mr. Serrano took place on August 23rd, 2024. And in order for me to do my job, I have to do some investigation regarding what my clients tell me. And I have an investigator by the name of Justino Sanpio. So I spoke to my client on August 23rd. On August 26th, 3 days after my conversation with Hector, my investigator reached out to the program director at Open Heart Elijah McFoley, McFolley. And my investigator asked Mr. Foley regarding any job that my client had, how he got paid. So 3 days after I spoke to Mr. Serrano and he gave me the breakdown of where the money came from, my investigator on August 26th spoke to Mr. Foley, who is the program director at Open Hearth. My client received a check on August 1st of 2024 for $324. He indicated to me 3 days prior, typically he has about $50 on him, and his sister gave him $270. If my math is correct, I come up with $644, and he was found with $651. Right in the ballpark. I had that information 3 days prior to my investigator confirming with the program director, and he received this. He was found with the money on August 13th. He has another check there. So the $324 check was cashed. Then he received another check afterwards. It was after the date for another $896, and they still owe him $10. So he was working, his family was contributing, and he told me, you know, I need some help paying things, so my family does help me. So that $644 that I said I had that information prior to my investigator speaking to the program is right in line with how much money he had on him. The money is still there. There's not any drug proceeds. The cops didn't take it to court and seize the money. We spoke to them, I said, on August 26th. And the money was still there. And then one of his family members it appears to somewhere down the road, picked up some of his belongings. So that money is still there. So math does add up in my opinion. I just wanted to pay. I understand what this says, but then when I did the math, and I said I had that information 3 days prior to get any confirmation regarding that. He's aware of the $50. The money just wasn't put where it was supposed to be. As I indicated, there's still $896 and whatever he was making an hour. So it's still a substantial amount of money that they're still holding for him.
But to be clear, on August 13th, 2024, he had, oh, sorry, go ahead.
I don't know if he wants me to translate or I can translate for him.
Yes,
Yeah.
Okay. Quería mencionar que para yo poder hacer mi trabajo, yo tengo que también investigar estos sucesos. Nosotros tenemos un investigador, Justino Sampaio, que trabaja en nuestra oficina. Previamente, cuando yo había hablado con el señor Serrano, él me había explicado acerca del dinero que él había cobrado. 3 días luego de esto, mi investigador habló con el señor Elijah McFoley, que es el director del programa, y él le comentó que sí, que Mr. Serrano había tenido un cheque que era en total de $224, que había cambiado $224 en cash. El señor Serrano tenía como $50 previamente con él. También su hermana, que ella lo ayuda económicamente, le había dado una cantidad de $276. Como mencioné anteriormente, yo tenía ya esta información 3 días previo a que el investigador pudiera confirmar esta información. En agosto 13 había otro cheque de $224. Todo esto era un total de $896, ya que la familia de él contribuye porque ahí tiene ciertas necesidades que ellos lo ayudan. Sumando estos cheques, esto es una cantidad de $644. Menciono nuevamente, esta información yo la tenía previamente a que mi investigador hiciera la investigación necesaria. Esto no era un dinero que estaba viniendo de la venta de droga. Él está al tanto de la regla de los $50, pero en este momento todavía ese dinero no se había podido poner donde era necesario.
I may make one comment before you ask me the question. I will concede my client had $651 as confiscated on August 13th. But the money that his sister, I believe his sister, hopefully I have the right person, was approximately $270. The check that was cashed was verified was cashed on 8/1 was for $324, and the 50 typically has on him comes out, my math is correct, to $644. Yes, $651 found on him on the 13th, but that money, as I indicated, was prior to, and it was verified that the check was at least $324 was verified by the program director. That was on August 1st. That's what I want to put on the record regarding that. That's my comments for the first part of the hearing. Obviously, I want to be heard about his background at the appropriate time.
Well, you answered my question.
Oh, I'm sorry.
You answered my question, that
Okay.
on that day, he was in fact and found with the 651.
Yes,
Okay.
yes.
Without.
It's still there at the house.
Okay. You want to translate?
Yeah.
Okay.
Fue un total de $651 en total que fueron confiscados del señor Serrano en agosto 13 del 2024. Me reitero, su hermana, entiendo que es su hermana, espero estar correcto, le dio un total de $270. Luego él cambió un cheque de 324 más $50 que él tenía. Si mi matemática es correcta, esto es un total de $654. Por lo tanto, vuelvo y digo, esto yo lo verifiqué previamente. Este cheque de $324 fue verificado de dónde venía ese cheque.
So I'm going to take anything further before.
No, not for the first.
Okay, so I'm going to take a moment before I announce my findings.
Voy a tomar un momento para anunciar mis hallazgos.
Okay, I'm back on the record. On charge 1, obedience to the law, I make a finding based on state's exhibits A, C, E, F, G, H, and L. On charge 2, halfway house placement, I make a finding based on state's exhibits A, B, C, E, F, G, and L. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history.
En el cargo número 1 hago un hallazgo que usted violó la condición de obediencia a la ley basado en la evidencia del Estado, exhibiciones A, C, E, F, G, H, E y L. En el cargo número 2, ubicación en Halfway House, hago un hallazgo basado en la evidencia del Estado, exhibiciones A, B, C, E, F, G y L. Esto concluye la parte de hallazgo de esta audiencia y ahora vamos a pasar con la defensa que va a hablar acerca de su historial. Counsel?
Yes, on behalf of Mr. Serrano, my client is 54 years old. He's been locked up since August 13th of 2024.
Mi cliente es un hombre de 54 años de edad, ha estado en prisión desde el 13 de agosto del 2024.
As previously indicated, the obedience to the law charge that was not lead in court. My client did not receive any jail time for that, nor did he plead guilty to any charges.
En el cargo número 1 de obediencia a la ley, este cargo fue anulado en corte. Mi cliente no recibió ningunos cargos.
Mr. Serrano was married for approximately 15 years, has 2 children, ages 33 and 34.
Mr. Serrano estuvo casado por 15 años y tiene dos hijos de edades 34 y 33.
Upon his previous release, he was at the open hearth until he was remanded on August 13th of 2024.
Al ser puesto en libertad previamente, él estuvo en el Open Heart Halfway House hasta haber regresado nuevamente a custodia el 13 de agosto del 2024.
On his previous release also, looks like in December of 2022, he did successfully complete the App Foundation residential inpatient substance abuse program in New Haven.
También en diciembre del 2022, al haber sido puesto en libertad previamente, él completó el programa de hospitalización de tratamiento para abuso de sustancias del APT Foundation.
And then it appears on March 30th of 2023 till May 23rd of 2023, he did successfully complete Connecticut Renaissance Inpatient Substance Abuse Program in Waterbury.
También del 30 de marzo del 2023 al 23 de mayo del 2023, él completó satisfactoriamente el programa de hospitalización de tratamiento para abuso de sustancias en Renaissance Halfway House in Waterbury.
Correct. As far as while my client is out in the community, he's always held employment.
Siempre ha mantenido empleo mientras ha estado en la comunidad.
His most recent job while he was at Open Hearth, he worked cleaning, basically cleaning in Hartford, street cleanup.
También mientras estuvo en Open Heart Works, él trabajó limpiando las calles de la ciudad de Hartford.
Also cleaned up at the riverfront in Hartford whenever there was an event there.
También limpió en Riverfront en Hartford cada vez que había un evento llevándose a cabo.
Previously worked part-time at a juice and milk factory in Ellington.
También trabajó a tiempo parcial en una factoría de leche y jugo en Ellington.
Also worked full-time as a dishwasher at the Palm House Cafe in West Hartford.
También trabajó a tiempo completo en el Palm House en West Hartford.
So while he's been out in the community, as I indicated, he's always had employment.
Siempre ha tenido trabajo mientras ha estado afuera de la comunidad.
It's indicated to us he's previously participated in the Explore program. He did about 13 out of the 26 classes prior to his remand.
También participó en el programa Explore, completó 13 de las 15 secciones.
And while out in the community, also received outpatient substance abuse treatment in the form of the Suboxone, as we put on the record. He does have a valid prescription for that, and weekly group at CRT in Hartford also.
También mientras estuvo en la comunidad recibió recibió tratamiento de medicación asistida en la forma de Suboxone y también estuvo participando de grupos semanales.
And it's indicated to us as far as housing, he'd like to be placed at the Connection Reentry Assisted Community, the REACH or Halfway House program in Hartford area.
También él nos mencionó que al ser puesto nuevamente en libertad condicional, le gustaría ser ubicado en la vivienda comunitaria asistida o the REACH Halfway House.
And he's also reported to us he can go back to the same job at Open Heart there, cleaning the streets in Hartford and working at the riverfront whenever there's an event there.
También mencionó que de ser puesto en libertad nuevamente puede regresar a su trabajo limpiando las calles con Open Heart Works y también con Riverfront.
Hector, anything I left out you want the hearing examiner to know about your plans for when you get out about going back to work and continuing your treatment? If you want to say something, now's your opportunity.
Es que si me dan la oportunidad, yo quiero salir para allá afuera, quiero ir a trabajar y continuar haciendo las cosas bien, haciendo los programas que ellos quieren que yo haga y hacer bien en la comunidad, porque yo estaba haciendo todo bien, estaba trabajando, estaba yendo a los programas, estaba haciendo todo lo que estaba supuesto a hacer, y no.
Yes, I just wanted to say that if I get the chance to be released again, I want to be able to go back to work, keep going to programs because I was doing everything that I was supposed to do when I was out there in the community. I was going to the programs, I was completing everything as supposed to, and I was doing good.
Okay, thank you. Anything further?
I don't have anything else to add.
No.
I'm going to take a moment before I announce my recommendation.
Voy a tomar un momento antes de anunciar mis recomendaciones.
And back on record, Mr. Serrano, this is your second violation since August 2022. You were in the community this time for about 2 months. And within that time, you didn't receive any misconducts as noted through the PBR, but you were aware of your halfway house agreement and expectations. Despite that, you were found in possession of marijuana, medication, and over $50. Based off of all of that and taken into consideration, I recommend revoke and re-parole on February 13th, 2025, which is an approximate 6-month sanction with the following conditions. Domestic violence, no contact with co-defendants Jacob Nowinski, Alfonzo Velez, and no contact with victims CA, ST, and IS, halfway house placement, and mental health treatment.
Mr. Serrano, esta es su segunda violación. Durante su periodo de supervisión, usted estuvo en la comunidad por un periodo de 2 meses y como mencionamos previamente, usted no tuvo ningún reporte de conducta. Sin embargo, usted estaba al tanto del acuerdo de su halfway house y usted fue encontrado en posesión de marihuana y la cantidad de dinero de $651. Por lo tanto, recomiendo que se revoque su libertad condicional y se restablezca en febrero 13 del 2025, el cual es un periodo aproximado de 6 meses de sanción. También yo recomiendo las siguientes condiciones: violencia doméstica, no contacto con coacusados Jacob Musinski y Alfonso Vélez, no contacto con las víctimas CA, ST y S, ubicación en Halfway House y tratamiento de salud mental.
My findings and recommendations will be forwarded to the board. You will receive the official written decision from the board and your board review is scheduled on November 14th, 2024. The board may lessen my recommended sanction or let my recommendation stand, or they can impose a sanction longer than what I have recommended, being that you are on supervision until August 30, 2034. If the board decides to impose a sanction longer than what I have recommended, then a supplemental hearing will be held.
Mis hallazgos y recomendaciones se emitirán a la Junta. Usted recibirá la decisión final en escrito. La revisión de la Junta está programada para el 14 de noviembre del 2024. La Junta puede disminuir la sanción recomendada, dejar mi sanción recomendada o pueden imponer una sanción más larga de lo que he recomendado. Si la Junta decide imponer una sanción más larga de lo recomendado, entonces se llevará a cabo una audiencia suplementaria. Antes de la audiencia, la Junta le proporcionará un aviso por escrito que determine que documente las razones específicas por las que podrían querer exceder mi recomendación.
So Hector, if you don't, it's going to the board on November 14th. You and I will get something in writing about 7 to 10 days afterwards with the final outcome.
Esto se va a llevar a la revisión de la Junta el 14 de noviembre. Usted recibirá algo por escrito dentro de 7 a 10 días.
Give me a call after November 14th. If you can call that Friday, give me a call. I can tell you over the phone what happened.
Deme una llamada luego del 14 de noviembre. Si usted me puede llamar ese viernes y entonces yo le puedo decir qué sucedió en esta audiencia.
Está bien.
Okay?
Thank you.
Thank you.
Thank you.